Welcome to the presentation, Don't Cry Over Spilled Contaminants, Statutory Obligations, Risks, and Practical Tips. Our presenter is Heidi Rolfe. She is an associate in the Environmental Municipal Expropriation and Regulatory Group in BLG's Vancouver office. Heidi has a wide range of legal experience guiding individuals, companies, and government agencies through regulatory processes, administrative and civil proceedings, as well as criminal environmental prosecutions relating to natural resource construction and other industrial projects. Heidi's service cover due diligence matters, permitting, including environmental assessments, land rights, including leases and other land access and tenure agreements, regulatory compliance, and emergency response. Over the course of her career, Heidi has also assisted developers and property owners dealing with redeveloping and remediating contaminated properties, including in disputes between neighboring property owners and navigating environmental cleanup orders. I'd like to welcome Heidi to the stage.
Thank you for that introduction, Anna. So today's presentation is about spill preparedness, response, reporting, and recovery. I'm going to cover two broad sections of legislation, both British Columbia and federal. This is not intended to be sort of a complete picture of every piece of provincial or federal law that applies to spills. It's to keep it a little bit more manageable for today. I'm going to focus on three statutes and the regulations that have the broadest impact across industries, being BC's Environmental Management Act, the Canadian Environmental Protection Act, and the Fisheries Act. So in BC, the former legislation, spills of contaminants, were governed by the Environmental Management Act and two repealed regulations. Under the former part of the EMA, the minister had the authority to order investigations, contingency planning, construction of works, or other measures that were necessary to prevent or contain a spill, and persons in control of a substance were required to immediately report. Under the now repealed version of the spill reporting regulation, only a verbal report was required, and there were no automatic requirements about written reports or impact assessments, though we were of course required to take actions to stop, contain, and minimize the effects of a spill. So there was quite a bit of discretion, and it was up to the minister to determine what was appropriate. This legislation was repealed and replaced between 2016 and 2017, and the new version of the EMA as it pertains to spills came into force in October 2017. This legislation establishes new requirements to enhance the management of environmental emergencies in BC with regards to spill reporting, response, and recovery. This change came about in response to concerns about potential spills from the proposed Northern Gateway and Trans Mountain pipelines. So the BC Liberal government at that time promised to implement a world-class spill preparedness and response regime. So the changes to the EMA and its legislative scheme overall has been divided into two phases. So phase one consisted of amendments to the EMA itself and the three new regulations listed here. As we'll discuss a little bit later on, these regulations create very onerous reporting requirements, not only during and after a spill, but also in anticipation of possible spills as well. So these are three broad themes from the amendments. They increase the preparedness requirements for transporters of liquid petroleum products. Overall, there are expanded triggers for response and recovery efforts, and there are enhanced cost recovery options for the government. So let's start at the beginning. What is a spill under the EMA? In essence, it's the introduction of a substance or thing to the environment that has potential to cause adverse effects to the environment, human health, or infrastructure. And in order to be a spill, it has to be not authorized under the EMA, so no prior permit would have been issued, and it can occur unintentionally or intentionally. Spill response are activities that would address the direct effects of a spill, and they're designed to limit the impacts. It begins immediately after a spill has occurred and ends when all reasonable efforts have been made to remove the spilled material. Under the EMA, there are two new categories of persons. The first of these is a, quote, responsible person. This is someone who has possession, charge, or control of a substance or thing when a spill of the substance or thing has occurred or is at imminent risk of occurring. That's an expanded trigger as well that you'll see there in that definition. This is a much broader category than the second, which is a regulated person. So this is a person who, in the course of conducting an industry, trade, or business, has possession, charge, or control of a prescribed substance in a prescribed quantity. So right now, this only applies to entities that transport certain substances that you'll see on the slide. So aviation fuel, bunker fuel, crude oil, diesel fuel, gasoline, etc. And only if they're in certain quantities as well. So this likely doesn't apply to this audience, but it's interesting that you might fall into the first broader category. So what is required of a responsible person? If a spill has occurred or is at imminent risk, there are certain things that you might have to do. So if a spill has actually occurred, it has to be reported immediately. You'll have to provide any requested information about what activities and things that you're doing to respond to the spill, as well as ensuring that skilled, experienced persons with resources and equipment are on site, responding to the spill, and implementing an incident command system. If a spill has occurred or is at imminent risk of occurring, then the responsible person has to ensure that certain actions are taken to address the threat or hazard caused by the spill. And this might include a number of different things, so assessing and monitoring, preventing the threat, stabilizing or containing a spill, identifying immediate risk to human health or the environment, as well as long-term effects. However, those are just the things that will always apply. There are also a number of things that may apply at the discretion of the minister. So the ministry is going to be reviewing information that's submitted by a responsible person, and that will determine its response and what else might be required. So as a result of this review, a responsible person may also be required to provide further information, take additional actions beyond what's actually prescribed. That might be the case if the director is of the opinion that bare compliance with the regulations is not sufficient to fully deal with the adverse effects of a spill on the environment, human health, or infrastructure. And you can also be required to develop and implement a recovery plan. And we're going to discuss that a little bit later when it comes to the regulations. When it comes to a regulated person, there are more onerous and different tasks that they might be asked to do. So they are required to carry out risk assessments. They have to prepare a spill contingency plan that complies with the regulations, ensuring employees receive certain training and test that spill contingency plan through drills and exercises, preparing certain reports, and implementing the plan if a spill should occur. Again, this only applies to transporters of certain substances. The amended EMA also provides for enhanced cost recovery on the part of the government. The EMA does allow the government to actually carry out spill response on behalf of a responsible person and can enter into private property for this purpose. They might do this in certain situations where they feel it's necessary. So if there is no responsible person in relation to the spill, or the ministry has reasonable grounds to think that government action is necessary, or a responsible person actually requests assistance from the government in dealing with response and recovery. Ministry actions can also include other tasks such as identifying and evaluating risks, measures to recover and restore the environment, and steps to resolve long-term impacts. The government can recover those costs from both a responsible person as well as the owner of the substance or things spilled in cases where those are two separate people. Costs are a debt due to the government jointly and separately between those two people, and recoverable costs are those that are deemed to be reasonable and may include use of government employees and contractors, use of government vehicles, external consultants and professional services, use of government equipment, research and analytical services. And it's also worth noting that a 25% administrative fee applies to those costs as well, and interest will also apply. In terms of how this process actually works, usually an environmental emergency response officer from the province will verbally inform the responsible person of their intent to recover government costs. And once all those costs are verified, a letter of demand will be issued, and either that will be paid by the responsible person, or they're also able to contest that with someone called the cost recovery clerk. Fines and penalties. It is the responsibility of regulated persons, responsible persons, and owners of substances to understand and comply with the EMA and its regulations, and failure to be in compliance can result in certain fines and penalties that you'll see listed here. And if a corporation were to commit an offense, employees, officers, directors, or agents who were either authorized, permitted, or acquiesced in that contravention might also be subject to penalties. Okay. Turning to the three new regulations themselves, the first is the Spill Preparedness, Response, and Recovery Regulation. So this regulation provides for something called a recovery plan that may be ordered by the provincial government in the event of a spill. This may apply when the director thinks that there are steps that must be taken to eliminate, mitigate, or compensate for damage caused by a spill. So it might be something like large volume spills, significant releases of a hazardous substance to a fish-bearing water body, or a public drinking water source. A recovery plan, recovery itself focuses on restoring the environment to its pre-spill condition. So it can also address things that, materials that could not be cleaned up, impact the environment caused by the response, and habitat losses. So the recovery plan itself just basically outlines how a responsible person intends to resolve or mitigate the impacts of a spill. Not all spills will require a recovery plan. In some instances, the responsible person may only be ordered to take recovery actions outside of a formal recovery plan. So situations where that might apply could be a minor amount of a hazardous substance has been spilled, if it's been contained to an isolated area, or immediate actions have reasonably eliminated some of those adverse effects. So this slide goes over what must be included in a recovery plan. So you can see that it is quite extensive. So it includes some basic things, summary of the spill, what was spilled, what are its properties, and how much was spilled, response activities that were taken out, pre-spill condition of the environment, and a spill's potential and actual impacts, as well as those related with the spill response itself. The impacts here that we're talking about can be wide-ranging, and they include effects on environment, human health, business profitability, cultural sites, or residential and business relocations. And the impacts must also identify any environmental and human populations that could be affected, as well as pathways that contaminants could take to cause adverse effects. So the plan also needs to be approved by the director. The director will then review it and either approve it or require it to be amended. The responsible person is then required to carry out the plan. This is all sort of in the vein of the polluter pays principle that the BC government implements with respect to the environment. It ensures that people who are responsible for spills are responsible for actually cleaning them up. So in this case, the responsible person will pay for preparing, carrying out, and completing the recovery plan. And once the recovery plan has been implemented, a conclusion report must be submitted to the director as well. And then the director may or may not issue a certificate of recovery to the responsible person. That might not be issued in certain cases where, for instance, it's too difficult to isolate the effects of one spill from a previous spill, or where multiple jurisdictions or stakeholders are being impacted or have legislative authority. Long-term effects of the spill are unknown, or again, just at the director's discretion. If restoration is not to sort of pre-spill, is not reasonably achievable, there are other options that the director may be willing to consider, such as offsite mitigation or an in lieu payment. Regulated persons are required to create a contingency plan by the following dates in 2018. Up next, we have the spill reporting regulation. This regulation creates very onerous reporting requirements when compared to the former legislation. It creates extensive requirements that were previously reserved for significant spills. In addition to having to report spills of listed substances in amounts greater than certain specified quantities, it is now mandatory to report a spill of any quantity of a listed substance that enters or is at imminent risk of entering a body of water. This goes even further than the Federal Fisheries Act, which only requires reporting of an introduction of deleterious substances into waters frequented by fish, so this applies whether or not those waters are frequented by fish. A responsible person is now required to provide 3 types of reports. First, there's an initial verbal report to the Provincial Emergency Program. And so that's very basic information, contact information for yourself, as well as for the owner of the substance, date, time, and location of a spill, description of the spill site and of the source of the spill, and a basic description of the circumstances and the cause of the spill. Things that you might know sort of in the immediate aftermath. Then updates to the minister are required to be in writing and to be made every 30 days until the end of the spill. So the end of the spill could be marked by things like an incident command post is disestablished, the source of the spill is either under control or emergency actions have been undertaken, and all emergency personnel have been removed from the spill site. And then finally, there's an end of spill report that must now be submitted within 30 days of the emergency response completion date. And this is much more involved. It really builds on that initial verbal report that was made. So you'll have to describe the circumstances, causes, and effects of the spill. So what was the activity during which the spill occurred, the incident that led to the spill, underlying causes, adverse effects to human health, to the environment and infrastructure, details of what spill response actions were taken, and you'll also need to include copies of all sampling, testing, and monitoring data. Finally, the reporting regulation also allows the director to order a responsible person to submit a lessons learned report within 6 months of the emergency completion date. So it could include, for instance, a description of the effectiveness of those spill response actions, description of things that you're doing to prevent future spills and improve response to future spills, as well as responses to any specific questions that the director asks in the order. So again, that's a discretionary requirement, and it could be quite broad. Finally, we have the Spill Contingency Planning Regulation, which essentially builds on the preparedness regulation. And again, this will apply to transporters of liquid petroleum products. generally speaking. So it lays out what these contingency spill plans must include, and these are the broad headings that you'll see on the slide. They are reviewed annually, tested every 3 years based on a worst case scenario, a discussion-based test, and an operations-based test. And all records must be maintained for 5 years. So that's where we are today. But as I mentioned at the top, there are 2 phases to this regulatory revamp that's happening in BC. So phase 2 regulations are now being considered. A policy intentions paper was released by the government in February 2018. And then engagement with the public, Indigenous peoples, other governments, industry associations, and interested stakeholders happened for the 60 days following that. And then in summer 2019, last year, engagement feedback reports were released. The new requirements focused around the following 4 policy topics that were being explored. So the first is prescribing response times to ensure timely responses following a spill, development of what they call geographic response plans to ensure that resources are available to support an immediate response, and one that takes into account the unique characteristics of a particularly sensitive or significant area, addressing losses of public and cultural use from spills, including economic, cultural, recreational impacts, and community response costs, to ensure that communities and Indigenous communities in BC are being compensated for negative impacts from spills. And that can include something like Indigenous food gathering access that might be limited following a spill. And finally, maximizing the marine application of the province's environmental emergency regulatory powers. So that's an area where there's both federal and provincial jurisdiction. So BC is aiming to maximize that to ensure that they have a consistent and high standard of protection in both marine and terrestrial settings. So we're going to go through a quick case study. So this is one example of a case that has been ongoing under the new spill cost recovery regime. My firm, BLG, represented MSP Transport in this case. So in December 2018, a truck was carrying frozen meat and it overturned in a river near Clearwater, BC. The ministry's environmental emergency program responded to the accident. So essentially the truck's trailer ripped open. Some of the frozen meat went into the river, actually this river that you see on the slide, and some vehicle fluids and diesel may have also spilled into the river. The truck itself was completely submerged. So in March 2019, you'll remember the government was involved in this, as I mentioned. So the ministry sent MSP an intent to pursue cost recovery letter, which basically just informed MSP that it intended to recover its costs. So several months later, in May, the ministry actually issued that demand letter. They call it a letter of demand for cost recovery. And it was signed by the acting recovery section head for the Environmental Emergency Program. And MSP was given 30 days to contest the letter, which it did in June 2019. The grounds cited by MSP in that the demand letter included GST. No information had been provided in support of the demand, so it was really hard to assess whether or not those costs were reasonable. And the government spill response actions were not, in fact, needed to ensure public safety or environmental protection. So at that same time, in June 2019, MSP appealed the demand letter to the Environmental Appeals Board. It did this basically to preserve its right to pursue an appeal, as it was really unclear as to whether the letter contesting the demand to the cost recovery clerk would act to stop the time period to file an appeal. The appeal was on the same grounds as the letter that was issued the same day. However, in several days later, the EAB rejected the notice of appeal on the basis that it had no jurisdiction, because the act that creates the board provides for appeals of decisions of a, quote, director, but the demand letter was issued by a recovery section head. So MSP requested the board would allow it to make submissions on that issue, and in September, the board accepted MSP's arguments that it had jurisdiction over the appeal. In those submissions, my colleagues argued that Section 99 of the EMA provides a broad right of appeal and that it should not be interpreted narrowly. We also argued that the demand letter is properly considered a decision of the director, and that reading the act as a whole and this section related to cost recovery as a whole, it's apparent that the legislator intended for the director to make decisions regarding spill response actions, and that demand letter is in all respects a certificate or an order related to cost recovery. The director's chief argument at this stage was that the demand letter was an administrative measure, informing MSP of its debt owing to the government by operation of law. The board first concluded that the director's decision to impose debt recovery could be framed as a decision under the EMA, and that means that that kind of decision could be appealed. The board also determined that in the circumstances, if it were to interpret the cost recovery sections to mean that it could not be appealed to the board, then MSP would have no clear way to challenge whether the costs in it were reasonable, necessary, or an appropriate response. And although the demand letter said that the demand could be contested with the cost recovery clerk, it did not explain the remedies that the clerk can provide. And if the costs are not appealable, nor are they subject to court scrutiny, there would be no independent review or appeal at all of the costs. However, the board later seemed to have resiled from that position and later stated that the amount of debt and who is liable for the debt are not decisions that can be appealed to the board. So it seems that we may be back to square one on this issue and may be deprived of opportunities to contest the costs. This matter has later settled and won't be proceeding to appeal, but it might be an issue that's going to come up again once the government starts to rely on those cost recovery provisions. So now moving on to the federal legislation. There are a number of federal laws that apply to spills, industrial accidents, and environmental emergencies. You'll see them listed here. I'm going to focus on CCPA and the Fisheries Act for today's presentation, but as the rest of them are quite specialized and apply in certain factual scenarios such as marine shipping or oil and gas operations. So starting with the Canadian Environmental Protection Act, or CCPA, the minister may require any person or class of persons to prepare and implement an environmental emergency plan respecting prevention, preparedness, response, or recovery in respect of certain listed substances that are included on what's called the list of toxic substances in Schedule 1, or substances or groups of substances that have been recommended or ordered to be added to that list. Interestingly, for this audience, chlorinated wastewater effluents are listed on that schedule. So any person who owns or has the charge, management, or control of a substance immediately before an environmental emergency or causes or contributes to such an emergency must now provide notification as well as a written report and must take all reasonable emergency measures. Things like preventing that emergency, repair, reducing, or mitigating negative effects, and making reasonable efforts to notify members of the public. So you'll notice that this really does mimic and follow the same logic as BC's new laws. So if a person were to fail to take the measures, an enforcement officer on behalf of the government may take those measures, cause them to be taken by a third party, like a consultant, or direct any person to take them. The federal government may recover costs and expenses reasonably incurred. There's now a national system for notification and reporting as well. So, and those requirements apply to the same groups of people who are subject to the spill reporting and response requirements. So in 2019, new environmental emergency regulations were put in place under CCPA. This, again, is very similar to the BC legislation, but is a marked departure from the former legislation. So this version of the regulation adds new definitions. So you'll see this term again, responsible person. In this case, it's a person who owns or has the charge, management, or control of a substance located at a facility. In this case, a substance is limited in that it only prescribes certain substances and solutions and in prescribed concentrations. So that means it has to be actually listed in the regulations to fall under these requirements. That's a little bit of a departure from the BC legislation, which uses a broader language talking about substances that could cause adverse effects. So a responsible person must notify Environment and Climate Change Canada prior just of the fact that they have this substance as a first step, and the new regulations expand both the number of substances to which the requirements apply and the regulatory requirements that apply as well. So for higher risk facilities, an environmental emergency plan must be prepared, brought into effect, and exercised. So this is really the core of these regulations, requiring the implementation of these kinds of plans to ensure that facilities are prepared to prevent and minimize harmful effects in the event of an emergency. The emergency plan must identify an environmental emergency that could reasonably be expected to occur at the facility and that would likely cause harm to the environment or constitute a danger to human life or health. It must also address what they call the worst case release, so a maximum quantity of a listed substance, or the worst case impact range, meaning an event with the longest distance effects from the facility's boundary. Schedule 1 of the regulation includes 249 substances that pose an acute hazard to the environment or to human health, and they fall into the following categories. So aquatically toxic, combustible, explosive, pool fire hazard, inhalation hazards, or oxidizers that may explode. So the regulations apply only, again, to certain quantities and container sizes of a Schedule 1 substance. Certain substances that are either used or created in water and wastewater treatment are included in this regulation. So that could be things like chlorine, chlorine dioxide, chlorination byproducts, hydrochloric acid, hydrogen peroxide, acetic acid, and peracetic acid. So something to look into if you're involved on the policy level at your organization. So compliance, facilities using or storing regulated substances are required to communicate with members of the public who may be affected by an environmental emergency. This includes communicating before an incident, so creating awareness of potential effects, providing notification of an emergency, as well as giving updates during and after an emergency. There are also new reporting requirements, so that's the notice of identification, the full-scale simulation exercises of an environmental emergency plan, and transfers of ownership of a facility, as well as facility closure. Persons subject to these regulations must also do annual and full-scale simulation exercises at least once per calendar year. and a full-scale simulation exercise must be conducted at least once every 5 years. So, moving on to the final piece of legislation we'll cover today, which is the Fisheries Act. The Fisheries Act prohibits a deposit of a deleterious substance in waters frequented by fish, any place and under any conditions where it, so meaning a deleterious substance or a resulting deleterious substance, may enter any such water. So in this case, fish includes parts of fish, shellfish, crustaceans, marine animals, as well as eggs and juvenile stages of fish. The exception to that would be deposits that were authorized by regulation. So if you're authorized either by the regulation itself or by certain permits under the Fisheries Act in advance, then it wouldn't apply. A deleterious substance, the definition, as you can see from the slide, is quite long, but it boils down to substances and waters containing substances in such a quantity or concentration that if they were added to water, or that water would be rendered or likely to be rendered deleterious to fish or fish habitat, or the use by humans of fish that frequent that water. And a deposit, again, is really any kind of activity that might have a substance end up in water. So discharge, release, spill, leak, seeping, it really covers the gamut. So if an unauthorized deposit of a deleterious substance were to occur, what is required? So first, there's a duty to notify. So if there's a deposit or there's a serious or imminent risk of a deposit of a deleterious substance, and it can be reasonably expected that fish habitat, or the use by humans will be detrimentally affected by that, then the duty to notify is triggered. And this is on the part of persons who own or have charge, management, or control of the substance or the work or undertaking activity that leads to the release of that substance, as well as to those who might cause or contribute to the occurrence. There's also a duty to take corrective measures. So that means that those same people are required to take all reasonable measures consistent with public safety and conservation of fish and fish habitat, as well as to prevent the occurrence if it hasn't occurred already, or to counteract, mitigate, or remedy adverse effects. And I should note for that this is also an offense under the Fisheries Act, and fines and penalties may be imposed. And that's the kind of case that we're going to talk about next. And then the government, as we mentioned before, can take corrective actions on behalf of persons responsible for the event, and they can recover those costs through a civil proceeding. So finally, we have one last example from case law, and this is a more local one. So in September 2014, Environment and Climate Change Canada was contacted. There was reports of an ammonia odor at Booming Ground Creek and Pacific Spirit Regional Park here in Vancouver, BC. The source was identified as being a refrigeration plant at the Thunderbird Arena at the University of British Columbia. It turned out that Simcoe Refrigeration and UBC had been completing repairs of the refrigeration system at the rink and had used a negative pressure device to purge residual ammonia vapors from the system. That mixture of water and ammonia was then discharged into a storm drain at the arena, and that flowed to the stormwater outfall through a ditch and into the creek. And that creek, Booming Ground Creek, is a tributary of the Fraser River. And then officers and park rangers unfortunately found approximately 70 dead fish in the creek in the 2 days following the discharge. And they also took samples, and the level of ammonia deposited in the water was analyzed and found to be harmful to fish. During the trial, Simcoe Refrigeration pled guilty. to a deposit of a deleterious substance. So that's the offense under the Fisheries Act. They continued with the trial for several more days, and UBC was later convicted of the following offenses: depositing or permitting the deposit of a deleterious substance into waters frequented by fish, so the creek, as well as places that may enter, that being the storm sewer in the ditch connected to the creek, as well as failing to report the incident in a timely manner. In June 2019, the court sentenced the parties to the following fines. Simcoe Refrigeration received a fine of $800,000, and UBC received a fine of $1.2 million. Those fines will be directed to the Government of Canada's Environmental Damages Fund, and UBC was also ordered to conduct 5 years of electronic monitoring of stormwater quality. UBC appealed its conviction under the Fisheries Act itself, the sentence that was imposed, as well as a more technical argument that us lawyers like to make regarding the dismissal of its application to stay the charges based on delay. So I'll skip over the delay issue. You can leave that to your lawyers. But the court upheld the conviction itself. So UBC had argued that the trial judge erred by finding that the deleterious substance was deposited into the creek, and by finding that UBC did not establish due diligence. UBC accepted that ammonia in a certain concentration that was deleterious to fish was found in the ditch, and that it came to be there from being dumped into the outdoor drain near the arena. But the challenge was based instead on the inference that the ammonia actually entered the creek, and they submitted that the trial judge erred in concluding that the Crown had proven what's called the actus reus, or the commission of the offense, beyond a reasonable doubt. The court upheld the trial judge's conclusion that the deleterious substance and said that this conclusion was unassailable, and that actually there's no requirement to prove the presence of a substance in a concentration that is deleterious to fish. Once it's determined that such a substance has been deposited, the offense is complete. So there's no language requiring a certain concentration there. And finally, the court also upheld the sentence that had been imposed, noting that particularly ammonia it's a very well-known noxious substance, and it was quite a large amount that had been discharged, as well that UBC knew the importance of pollution and prevention and had failed to explain why it hadn't extended its policies to the arena. So on that basis, the court concluded that UBC's appeal could not succeed. I'm not sure. I think we're probably close on time, but if anyone has any questions, I'm happy to take them. Okay. Okay, the first question is, in the spill reporting regulation, it does not identify potable drinking water chlorinated, and I assume it would fall into the other category. I'm not sure of the other category, I don't have it in front of me. So 200 liters is very easy to exceed. Could this carry over into private homeowners who are spilling irrigation water? I think sort of off the top of my head, my guess is probably not, but it does depend on, in every case, we would have to consider that based on the amount as well as what is actually carried in that water. So if that water were to carry certain substances, perhaps fertilizers in a very high concentration, then it might meet the requirement for reporting. Okay, and so the next question is, if, say, another Valdez occurs in international waters but affects both countries, does the Canadian legislation apply as well as US legislation? Would one exceed the other? This is actually a very complicated question. So within your territorial waters, the Canadian legislation would apply. In international waters, there are international laws and treaties that actually apply to that situation. So it wouldn't necessarily be one applies versus the other. but there is consistency usually between US and Canadian regulations. Okay.
Thank you very much, Heidi. That was so informative, and I enjoyed the case studies as well.
Yes.
Thank
Thank
you on
you.
behalf of the EOCP for presenting.
Okay, great. Thank you.